तो चलिए शुरू करते हैं. Look, if you're gearing up for the All India Bar examination, you already know that criminal law doctrines can, well, sometimes feel like just a massive drywall of text. But today, we're tossing that traditional textbook right out the window. We are going to master 20 essential criminal law doctrines for AIBE 2026, and we're going to do it by stepping straight into the middle of a high-stakes, cinematic courtroom drama. So think of me as your showrunner and this explainer as your binge-worthy season finale.
Picture this setup: a murdered victim, a missing weapon, and a highly tense courtroom where 20 critical legal doctrines are literally going to decide a man's fate. This isn't just theory, guys. This is your survival guide for the exam. We're going to watch a fictional trial unfold, and through every single objection, every cross-examination, and every piece of evidence, you'll learn exactly how these doctrines operate in practice, and more importantly, how they're going to be tested on your exam.
Section 1. The Missing Corpus Delicti.
Okay, our scene opens on a dark, rainy night. Police sirens are wailing as investigators arrive in an abandoned warehouse. There's blood on the floor, there's a shattered watch, but the lead inspector turns to his team and asks one crucial question: where is the body? And this, right here, brings us to the foundational rule of Corpus Delicti, literally the body of the crime. You see, before the prosecution can point fingers, before they can make any dramatic arrests, they absolutely must first prove that a crime actually occurred. Because if there's no proof of a crime, no corpus delicti, there's just no case. It's the absolute bedrock of criminal jurisprudence.
But obviously, the police don't give up that easily. The prosecution starts building a web of circumstantial evidence, a complete Chuck review. Let's break down the timeline they piece together. At exactly 10 p.m., the accused and the victim were last seen together. Now, this doctrine is critical. If you're the last person seen with the deceased, the burden of proof actually shifts to you to explain what happened. Then at 10:30 p.m., a neighbor hears desperate screams. This triggers the doctrine of res gestae, meaning facts that form part of the same transaction are incredibly relevant under the Evidence Act. And finally, by 11 p.m., the victim vanishes. The web is officially set.
Section 2. Guilty mind, guilty act. Let's flash back for a second to a tense law school classroom years earlier. The rain's beating against the window. A strict, heavily intimidating criminal law professor slams a heavy book down on the desk, aggressively locks eyes with the front row, and yells, "Mere intention to commit a crime is not punishable. You can think about committing a crime all day long. Tobitao, where is the mens rea without the act?" It's a classic trick question, designed to test the absolute fundamentals of criminal liability. A curious student in the front row confidently fires back. To establish criminal liability, professor, you need both sides of the coin. And they're exactly right. On one side, you have mens rea, the guilty mind, which includes intention, negligence, or recklessness. But on the exact other side, you absolutely must have actus rea, the guilty act, the physical commission of the offense. Without that physical act, a guilty thought is, well, it's just a thought.
So the real trick is knowing exactly when a thought actually turns into a crime. First, the intention forms. Second, preparation happens, maybe buying a weapon or mapping out an escape route. Now, preparation is usually not punishable. But step 3 is where the doctrine of attempt kicks in. And listen closely because this is highly testable for your MCQs. The exact moment preparation ends and a direct movement toward the offense begins, that is when a crime has officially occurred. That transition is everything.
Section 3. Conspiracy and common intention.
All right, snap back to the present. The courtroom air is just thick with tension. The rival counsel stands up, points directly at the accused's friend sitting in the gallery, and drops a total bombshell.
Ye koi single act nahi tha, my lord. This was a syndicate.
He's formally charging them using the doctrine of conspiracy. This means there was a prior meeting of the minds, a clear agreement between 2 or more persons to commit an illegal act. In the eyes of the law, the very moment they agreed to this dark plot, they crossed the line into criminal liability, even if some of them never threw the final punch.
And this brings us to the ultimate AIB heavyweight matchup of constructive liability. In the left corner, we have Section 34, Common Intention. This requires a shared intention, meaning everyone is equally liable for the whole act. Think of the famous Mahbub Shah v. Emperor case here. And in the right corner, Section 149, Common Object. This applies specifically to unlawful assemblies, where every single member is liable for an offense committed in prosecution of that object. Both of these doctrines essentially hold one person liable for the acts of another simply because of their participation.
But wait, the defense vakil jumps in and argues, "My lord, my client didn't have the required guilty mind."
Well, the prosecution counters that with two massive exceptions to the mens rea rule. First up, strict liability. This is where punishment happens even without proof of a guilty mind in specific statutory offenses. Second is vicarious liability, where you're held liable for another person's act. Now, while that's normally absent in criminal law, it absolutely applies if a statute specifically provides for it. You literally don't need intention if the law says you're strictly liable.
Section 4, Courtroom Clash, the defenses.
Okay, it's time for the defense to strike back. A brilliant senior advocate steps right up to the podium for cross-examination, and the whole courtroom just holds its breath. "Objection, my lord," they shout, totally altering the narrative. They claim the accused actions were driven by the doctrine of necessity, meaning they committed a smaller offense simply to prevent a much, much greater harm. And, furthermore, they argue it was triggered by the doctrine of provocation. If the accused was subjected to grave and sudden provocation, it can legally reduce a massive charge of murder all the way down to culpable homicide. But the prosecution sneers, right, but what if he hit the wrong person during this so-called defense? This highlights a really crucial contrast in the law. On one hand, you have the doctrine of transferred malice. If you aim at person A but accidentally kill person B, your guilty intention completely transfers to the actual victim. You're still fully liable. But on the other hand, under sections 96 to 106, we have the doctrine of private defense. If you use proportionate force just to protect your own body or property, the act is justified and entirely lawful.
Section 5. Judgment and benefit of doubt. So, the arguments have concluded. The dust has finally settled. The judge adjusts his glasses, preparing to deliver the final verdict. But out of nowhere, the prosecution submits one last highly dramatic piece of evidence, a dying declaration. This is a statement made by the deceased right before they passed, explaining the exact cause of their death. It's admissible under Section 32 of the Indian Evidence Act, because the law essentially presumes that a dying person is not going to meet their maker with a lie on their lips. It's a highly emotional, incredibly weighted piece of evidence.
However, the defense's cross-examination punched some pretty massive holes in the timeline. Now the judge faces a serious dilemma and has to fall back on two absolute bedrock principles. First, the doctrine of innocent until proven guilty, which is the very foundation of criminal jurisprudence. And second, if the prosecution's evidence is shaky in any way, the doctrine of benefit of doubt applies. Bottom line, if a reasonable doubt exists, the accused must be acquitted.
But here is the ultimate plot twist that makes the entire courtroom erupt. The judge dismisses the case entirely. Why? Because of the doctrine of double jeopardy. It actually turns out the accused was already tried and acquitted for this exact same set of facts in a completely different jurisdiction years ago. Under Article 20, Clause 2 of the Constitution and Section 300 of the CRPC, a person absolutely cannot be punished twice for the same offense. Case closed.
Section 6. AIB 2026 Final Revision.
All right, let's step out of the courtroom for a minute. If you are really focused on passing the AIBE 2026, we need to extract the testable data here. You must be able to instantly link common intention to Section 34 and the Mahabub Shah case. You need to instantly recognize double jeopardy under Article 20, Clause 2. Private defense, that's Sections 96 to 106. And the dying declaration is firmly planted in Section 32 of the Evidence Act. Map these doctrines directly to their sections, guys. It is pure gold for passing those AIBE multiple choice questions.
If you only take away 3 things from today's explainer, please make it these. Number 1, always know the difference between Section 34, common intention, and Section 149, common object. Number 2, remember that criminal liability almost always demands both actus reus and mens rea together. And number 3, never forget the exceptions to that rule, like strict liability and vicarious liability.
To make sure this really sticks with you when you're sitting in the exam hall, I want to give you a super easy memory trick. Just think of the word camp. To successfully prove a crime, the prosecution has to establish C-A-M-P. The corpus, meaning the body of the crime, the actus, the guilty physical action, the mens, the guilty mind, and the presence, meaning the accused has no alibi. If you can just remember camp, you'll easily navigate the foundation of pretty much any criminal liability question they throw at you.
And as we wrap up this explainer, I want to leave you with a thought that legal scholars have literally debated for centuries. We just saw the judge apply the benefit of doubt. But consider this, if the doctrine of benefit of doubt lets a potentially guilty person walk free, is our criminal justice system truly designed to protect the innocent, or is it simply designed to demand absolute, perfect evidence from the state? Keep that question in mind as you continue your legal studies. Good luck on the AIBO, and keep pushing forward.